Hey everyone, it's Rob Ryder. I want to point out a canon that's in, this is in the Roman Rite Code of Canon Law. Canon 1397 says, one who commits murder, or who by force or by fraud abducts, imprisons, mutilates, or gravely wounds a person is to be punished according to the gravity of the offense with the deprivations and prohibitions mentioned in Canon 1336. So, if you were unlawfully arrested or unlawfully imprisoned, this would apply to whomever did it to you. And all you need to do is prove that it was done by fraud or by force. Well, how would you prove it was done by fraud? Pretty simple. If there's no sworn complaint against you, then you can't be charged for a criminal offense. And I believe it was, I talked to him, I think it was Handcuffed John in Virginia who told me, when he was down checking on his numerous traffic violations and trying to clear his good name, that the clerk of the district court in Virginia told him, well, nobody ever files a sworn complaint. Thank you, Jesus, thank you, Lord, thanks for the witness. There's no sworn complaint, therefore you can't be charged with a criminal offense. If they're not going to swear to the complaint, it was fraud. If you were in prison or abducted, well, then there's supposed to be a penalty that goes to it, and you could go to the church, the Catholic Church, and have them deal with it. That's what this is saying. Now, I'm not going to say that the people in the church know this. In fact, most of them I don't think do know this. I think that they're as dumb as a box of rocks as far as the law is concerned. They're just doing things the way they have ever since they took the job, and because we've taken situations to them in the past and they've said, well, we don't get involved in civil matters. And excuse me if I cough in your ear, forgive me. But what we did then is, basically turned around and walked out the door and went and looked for a different answer instead of going back in and saying, well, no, this is a church matter because it's a matter of faith and sin. And so, that's what these videos are on the church stuff, is to show that this is what it actually says that they have jurisdiction over, and trying to point out the types of things that would put it into within their jurisdiction, and then take it to the church and make them deal with it. So this is Church and State Part 2. Basically who has jurisdiction over what. And I'm Rob Ryder, and today is Halloween, I guess, 10/31. My email address, courtofrecord@aol.com. My phone number. And if you can donate, please do. My PayPal account is my daughter's email address, ashleyritlewski@gmail.com. Or if you can, rather send it by mail, then there's the snail mail. Robert Ritlewski, 10955 14 Mile Road, Rockford, Michigan, 49341. So let's recap first of all with from the last video, which some of these are running kind of long. There's just so much information to go through. But let's take a look at this. So the church and state are both perfect societies. That is to say, each essentially aiming at the common good, commensurate with the need of mankind at large and ultimate and generic kind of life, and each juridically competent to provide all the necessary and sufficient means thereto. Basically, they're two separate perfect societies, not dependent. Neither is dependent on the other. All rights and duties on earth come ultimately from God through the divine law, either natural or positive. Now, this is within their jurisdiction. They're not dependent on each other. So, all rights and duties of earth come ultimately from God through divine law, either natural or positive. Basically, this big ball we live on is the property of Lord Jesus Christ. We can't own it, as far as we're not taking it with us, but we can have the right to enjoy, right to use, right to dispose of. Ownership rights. We can be the rightful proprietor. And so that's what the temporal order was supposed to set up. And I don't have it in this video, but there's a document that was prepared as part of the Vatican II that talks about the lay apostolates that would be us as the lay apostles, not apostates, apostolates, and that our duty is to conform the temporal order to the will of the Lord. The temporal order is the state and, the world, the earth as we see it, and we're supposed to conform it to the will of the Lord Jesus Christ. So, and the church will help us do it. Once we convince them, it's within their jurisdiction. And, so as a for instance, Bob in Arizona has gotten the apostolic signatura by going to the chancellor of his diocese. They've forwarded his petition to the apostolic signatura. So, we can get him to do something. Now, we'll see what the apostolic signatura does, but up until that point, all we had ever been told by anybody that went into the church is, well, we don't get involved in civil matters or things to that event, trying to get you to leave. Instead of saying, no, for these reasons, boom, 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 it is in your jurisdiction. And we're going to wait and see what comes out of it. The goal then of the church is the perfect supernatural happiness of man, its proximate purpose to safeguard the internal moral order of right and wrong, and its external manifestation, right? So basically, internally, are you doing things right and wrong, and what is the external manifestation of your internal decision? Well, what they're going to do is safeguard the moral order of the internal right or wrong. If you're morally doing something wrong, the church is going to step in and say, you can't do that. And then the external manifestation won't happen. It is clear, therefore, that the purpose of the church is higher in order of divine providence and of righteous human endeavor than that of the state. The church has a right to preach the gospel everywhere, willing or nilling any state authority, and so to secure the rights of its members among the subjects of any civil polity whatever. So, who are its members, who's members of the church, who's subject to the church, because it doesn't matter where they are, what civil polity, what civil society they're subject to. If they're subject to the church is over the state, and they have to answer to the church. The church has a right to govern her subjects wherever found, declaring for them moral right and wrong, restricting any such use of their rights as might jeopardize their eternal welfare. Got to save that soul. Right? Some people believe that they have, freedom of conscience. They can go do whatever they want. Well, that means, they can go pray in church all day Sunday, beg forgiveness, and then pray on you all week long to take your property. Well, that isn't correct. I don't know where that doctrine came from, but that's an improper doctrine that the church can do something about. In all purely temporal subject matter, so long as it remains such, the jurisdiction of the state over its own subjects stands not only supreme, but as far as the church is concerned, alone. In all purely temporal subject matter. In all purely spiritual subject matter, so long as it remains such, the jurisdiction of the church over the ecclesiastic subjects obtains the complete exclusion of the state, nor is the church therein juridically dependent in any way upon the state to exercise of its legitimate powers. Matters of faith and sin are the church's jurisdiction. Purely spiritual subject matter is primarily made up of human acts necessarily related as help or hindrance to man's eternal happiness. Right? So you're trying to create your own happiness. Well, are you doing it by stealing your brother's property or by your own hard work? Right? If you're trying to steal it from your brother, well, then the church can step in. The last end of the church, and at the same time, indifferent in themselves as a help or hindrance to man's temporal happiness. Secondarily, it extends to all persons and external objects as involved in such acts. So you've worked really hard to have this deed for a piece of property, and somebody's trying to take your property from you. But you purchased it with a warranty deed. It says on there that the grantor was happy with the deal. He's been paid. He signed off. Well, then why are they trying to take your property? They're trying to say that through this deed of trust, mortgage, whatever, which is really a security agreement that hasn't been signed by one party, it only has your signature on it. It's a unilateral contract. All a unilateral contract is a contract with the signature of one person can be used for is for gifts and estate. Or, excuse me, for gifts or donations. Right? If it's a business contract, well, both parties need to sign it. Now, when you went to the bank to get a loan for your property, did you plan on giving them your property as a gift or donation? Or did you think you were going in there to do a business transaction? I'm going to say the business transaction. Did they sign the contract? No, so there's no freaking contract. They never lent you the money. It's that simple. Just got to find the right person to make the argument to. All right, so now it's a matter of faith and sin. I don't have to deal with the frickin' civil courts. I can take it to the church court. And all subject matter not purely spiritual or purely temporal, but at the same time both spiritual, temporal, and character, both jurisdictions may enter, and so entering give occasion to collision, for which there must be a principle of solution. So if it's mixed temporal and mixed spiritual, such as an acknowledgement on a document under notary seal, which now gives the church concurrent jurisdiction, it could go civil or it could go church. But who's going to be the ultimate authority? Well, in the case of direct contradiction, making it impossible for both jurisdictions to be exercised, the jurisdiction of the church prevails and that of the state is excluded. The church trumps the state. In point of fact, the duty of submission in a citizen of the state to the higher jurisdiction of the church does not exist where a citizen is not a subject to the church. So like the dear leader in North Korea probably has not been baptized and isn't subject to the church. I don't know, maybe has been. You know, who knows? They have the records back in the Holy See in Vatican City. For over such the church claims no governing power. Haven't been baptized, the church doesn't claim any power. It may also be by accident subjectively obscured in one who in point of right, the church is subject, so they are the church's subject, in good faith, though, through an erroneous conscience, to recognize this fact. So, just because they have an erroneous conscience, they have an error in their conscience, and so they don't realize that they are the church's subject, and by consequence, the church is right in his own duty. They don't see any of that because they got an erroneous conscience, right? They're in error. So who are these people? The subject of the state has been made fairly clear by human law and custom, but the frequent rebellion, continued through centuries, of great numbers of the church's subjects, has confused in the mind of the non-Catholic world the notion of who is, by revealed law, a subject of the church. The juridical subject of the church is every human being that has validly received the sacrament of baptism. For baptism is a sacrament leaving an indelible character upon the soul which man cannot remove and so escape legitimate subjection. Yet, as in a state, a man may be a subject without full rights of citizenship. Now, this is interesting. Yet, as in a state, so in a state, you could be a subject without full rights of citizenship. I think that's how we are right now. But what this is also saying is, you could be in the church and have citizenship. Or you could just be a subject. So, yet, as in a state, or in the church, a man may be a subject without full rights of citizenship, may even while remaining a subject lose those rights by his own acts or that of his parents. So, analogously, not every subject of the church is a member of the church, is a citizen of the church. And once a member, a citizen, he may lose the social rights of membership, citizenship, in the church without ceasing to be its subject. So, technically, we should all have, those who chose to be members instead of subjects of the church, should have a passport from the Holy See. That's where your travel documents should come from. You're a citizen of the church, not a citizen of the state. In fact, you're not a citizen of the state right now because you cannot go into your drawer and produce a certificate of citizenship. You may be a native-born American, but you're not a citizen of the United States of America because you ain't got a frickin' certificate of citizenship. It may be presumed that you're a citizen, but it isn't lawfully that you are because there's no certificate of citizenship. Bobby in Arizona tried to get one. They do exist. Last year, they wouldn't let him take the oath required to get a certificate of citizenship. They don't want you as a citizen. They want you as a subject. Well, in the church, for the same reason, you could be a subject or a member, citizen, but you could also lose that. And here's one way. Canon 842, a person who has not received baptism cannot validly be admitted to the other sacraments. Okay, that's simple enough, but it's number 2. The sacraments of baptism, confirmation, and blessed Eucharist so complement one another that all 3 are required for full Christian initiation. So, in my opinion, to be a member of the church, you have to have baptism, confirmation, and the blessed Eucharist or First Communion. Now, I'm a good little Catholic boy, man. I went to Catholic school for 6 years. I wasn't that good, but hey, I was there. And I know that I was baptized, and that at the age of 7 we had Holy Communion, and at the age of 9 we went for confirmation. And sure enough, when I got my baptismal certificate here recently from my parish, it shows when I was baptized and it shows when I was confirmed. But there's a big blank, an omission, where it should say First Communion. It's not been written in there. And I was talking to Jeff out in Washington State about this, and he started making some phone calls and talked to the archivist at his diocese and found out, yeah, they used to put it in there, but like in the middle of the 20th century, so let's say the 1950s, they stopped doing it. And it's just assumed that you are. I said, and he said, well, you must have if you've been confirmed because you would have had communion first. There you go, right? But the actual record itself does not show that you have had the Blessed Eucharist, so therefore, by Canon 842, you are not a full Christian, initiated as a full Christian within the Catholic Church. So this is, so what do you do about that? Well, here we go. This is where this apostolic signatura came in, because in Canon 1445, the Supreme Tribunal of the Apostolic Signatura adjudicates complaints of nullity or petitions of reinstatement and other recourses against rodal sentences, and recourses in cases concerning the status of persons which the Roman Rota refused to admit in a new examination. So, what that means to me, as we're going to see that the bishop of the diocese is the judge of first instance, you would bring this to his attention, and if he won't fix it, then you can appeal to the Apostolic Signatura, right? Because if they refuse an examination to check your status as the bishop, well, now I can go to the Apostolic Signatura and have them do it. Hence, those validly baptized Christians who live in schism, or whether by reason of apostasy or initial education profess faith different than that of the church, are excommunicated therefrom, such as by becoming a Freemason, are not members of the church, though as a matter of objective right and duty, they are still her subjects. In practice, the church, while retaining her right over all subjects, does not, except in some very few matters not of moment here, I'm not going to tell you what they are here, insist upon exercising her jurisdiction over any but her members. So right now she only exercises jurisdiction over priests, bishops, nuns, people of the holy orders, who are her members and have the citizenship of the right to have an office within the church. Now, in the Pontifical Council for the Laity, another decree that came out of Vatican II, it talks about the special office that has been created within the Holy See for the lay apostolate, the lay apostles, known as a Christi Fieldis. And if we have that office within the Holy See, well, every time anybody who claims an office comes with whatever the office comes with. Like a benefice, like an honorarium, like whatever. So now you don't have to work for a living like a dog. You go to the church, you get your property, you get control of your property, and you go out in the world and you conform the temporal order to the will of the Lord. Right? You're a mission church out preaching the gospel and telling these frickin' people in these courts, you can't do that. Ask them some questions. Are you a baptized Christian? Boom, well, I'm taking you to church court. I got another question for you. Are you a member of a secret society? Are you a Freemason? If you are ipso facto already excommunicated from the church. What we want to do now is get the memorial to the event, because it's just, right now, spiritually they've been excommunicated. I want it on paper. I want it to be a record in the Holy See that Judge whomever is excommunicated from the church for being a Freemason. Because I believe if he's been excommunicated, he cannot hold an ecclesiastic office, and I think a judge's position within the state government is an ecclesiastic office. I think that all constitutions are ecclesiastic ordinances. Anyways, as it is clear, she cannot expect obedience from those Christians who, being in faith or government separate from her, see no right in her to command and consequently recognize no duty to obey. All right, that's why they don't try to enforce it. Doesn't mean they can't, because it says here, except in some few matters. Not a moment here. Well, there are matters that they can, and one of those matters would be if you're trying to commit fraud against me. Over those who are not baptized, she claims no right to govern, though she has the indefeasible right to preach the gospel among them and to endeavor to win them over to become members of Christ's church and so citizens of her ecclesiastic polity. Well, what's her ecclesiastic polity? It's the Holy See. The state is bound to recognize the judicial rights of the church in all matters spiritual, whether purely so or mixed character. The state is bound to protect all the rights of its citizens, and among these, their religious rights. All right, so we have this thing called, protection, equal protection under law, and no discrimination against religion. And this comes in, and one of the things we're trying on the other side of the fence in the administrative part of the government. In Michigan, they have an office called the Office of Civil Rights. And in there it talks about discrimination, for religion, race, whatever. And, one of the things they guarantee is equal protection of the laws or something to that effect. Right? So, first of all, you got to prove to them you have a religion. Well, that's what your baptismal certificate is. I have a religion. I'm a Christian. Here's my certificate. And now, because I have a religion, you cannot discriminate against my religion, and you have to make sure I get equal protection of the law. Well, the law says that if you're going to have a complaint against me, it has to be sworn to. If there's no sworn complaint, they're not following the law. Pretty simple. To have the further right to command the state in their regard implies that the church has right to impose obligations of her authority in regard to exact them authoritatively from the state. Did you know that the ambassador from the Holy See sits at the head of the table when the other ambassadors get together? I find that quite interesting. Now, in purely temporal matters, while they remain such, the church cannot command the state any more than she can command the subject of the state, even though these are at the same time her own subjects. But in spiritual and mixed matters, calling for corporate action of the state, the question depends on whether the physical persons who make up the moral personality of the state are themselves subject to the church. Is Obama a Christian? Is Hillary Clinton a Christian? Right? Are they Christians? Have they been baptized? If they are, then their physical person makes them a subject of the church. In case they are, the church has, in consequence, jurisdiction therein over the state through them. And so we need to bring it to the church's attention that things that we find wrong with the government that are morally incorrect, right? There has to be an element of faith or sin involved in what they're doing. But if it's not moral, Then you take it to the church, and the church, because they have jurisdiction over all baptized people, can go to that baptized person and say, look, you can't do this. We're going to have to give you a timeout. We're going to have to bring the confessor with his red hot poker, see if you fear God. If then the physical persons constituting the moral person of the state are the subject of the church, they are still in this joint capacity subject to her in like matters, namely in the fulfillment of the civil duties of the state towards religion and the church. The church, because of the uselessness of her insistence or because of the great evils to be avoided, may waive the exercise of this jurisdiction, but in principle it is hers. For a state once Catholic, and in union with the church to declare a separation on the ground that it has ceased to be Catholic, is an action which, as similar of objective right, has no standing. This really applies more to Europe than the United States. The United States was never a Catholic nation, but most of Europe was at one time a Catholic nation. It may be noted in passing that in recent instances of separation of France and Portugal, the breakup of the existing condition of the union between the church and the state. So France and Portugal used to have a union of church and state, and was broken up. The separation has been effected where the bulk of the people are still Catholics. They didn't ask for that to happen, and has been conducted in violation of rights and contracts, both natural and positive, and has resulted, as it was aimed to do, in an attempt at complete subjection of the church and of all civil subjects in the matters of religion to the tyranny of administrations which scoff at all religion. In other words, the Freemasons tried to take over the administration of the church. They're a bunch of devil-worshipping pagans, and then it didn't matter what religion you thought you had, they're going to scoff at all of them. And so the church is saying, hey, this, whatever you think you did is unlawful. And, the church will eventually come back and set things right. It's happening right now. If you pay any attention to Putin in Russia, right? Putin's a Christian. He's an avid Christian. He's all for protecting Christianity. He just recently came out. I have to laugh at this. It was him and I think Cameron for the UK having some kind of little thing. And anyways, the question got around to supplying arms to the rebels in Syria. And Cameron had his say, and what Putin basically said was, well, Europe has a centuries-long traditions on, morality and so forth. And do you really want to give arms and comfort and relief to an institution or a group of people that eats the organs of their adversaries? Right? Because if you didn't know this, right, that's what them Satan's subjects are doing over there in Syria, right? They're eating the organs of the people they kill. They're devil worshippers, and that's who the United States is backing, and England is backing. As the power of the church extends not only to its individual members but also the whole corporate body, not only to questions concerning the conscience, but to public actions of its subject, the ecclesiastic jurisdiction is distinguished into that of internal and external forum. The church's jurisdiction in the external forum has reference to matters touching the public and social good of the corporate body. It corresponds consequently very closely to the powers exercised by civil magistrates in affairs belonging to their competence. Go figure. While the external forum may busy itself with concerns of individuals, it does so only in as far as the effect of public good. Thus, the absolution of sins belongs to the internal forum, but the concession of the faculty for performing such absolution is an act of the external forum. Okay. The jurisdiction of the external forum is subdivided into voluntary and necessary. Voluntary, or extrajudicial, is that which a superior can exercise towards those who invoke his power, or even against those who are unwilling, but without his using the formalities prescribed in law. In other words, he can make a summary judgment, a judicial determination, and make a summary judgment. If you invoke his power and you give him a reason why he can do what he's doing, he can make a summary judgment. Doesn't have to have a court case. He can make a phone call. Necessary or contentious jurisdiction is that which a judge employs in punishing crimes or deciding disputes according to the prescribed forms. So contentious jurisdiction is in personam jurisdiction. One man against another man. You're going to bring the judge, not as a judge, but as a man into the church court to say he rendered a false verdict against you. Or that the attorney of record is committing perjury. Or that the plaintiff doesn't exist, and therefore the attorneys brought fraud upon the court. Or that the policeman didn't sign or take an oath to his complaint, and therefore there is no complaint against you. That would be the same for an IRS issue. Nobody has signed a frickin' sworn complaint against you. So how can you be charged with a crime? Necessary contentious jurisdiction is that which a judge employs in punishing crimes or deciding disputes according to prescribed forms. In general, the articles of jurisdiction of the external form are the decision of disputes concerning faith, morals, and discipline, and making and enforcing of laws, the punishment of transgressions, ecclesiastic statutes, and the like. Well, what are ecclesiastic causes? Themselves are called civil. So when they say it's a civil matter, well, that makes it an ecclesiastic cause. Tell that to the church. When they say we don't get involved in civil matters, sure you do. You call ecclesiastic causes civil. When they concern either spiritual things, as the sacraments, or matters connected to them as church property, the right of patronage, and. Now, what is church property? Let's think about this. Your body is supposed to be a temple for the Holy Spirit. That makes you a church. Your body is church property. It's a bunch of dirt, man. It's church property. And all this church property is under the legal name of your juridic person. Right? Your legal name, all caps name. Your natural is your upper lowercase name. That's the animal. Right? But the legal name is your all caps. And all your property, church property, is accounted for under your all caps name. It's your property. What they're keeping you from doing is signing your name to get access to your property. And I think if we become citizens of the church, claim our office, we're going to have access to our private property. They are called criminal when they involve the dealing with delinquents guilty of simony, apostasy, schism, and the like. They are called mixed when they are subjects proper for decision by either ecclesiastic or civil forms, such as a usurious contract. We're going to use this one. Concubinage, violations of the church peace. Causes are likewise called mixed when they have both spiritual and temporal end. To this class of mixed causes can also be reduced the suspension of heresy, where church and state cooperate with each other for the maintenance of the integrity of the faith and preservation of the civil peace. Freemasons, ipso facto. Did I put this in? Freemasons are ipso facto excommunicated because they're for being a heretic. If you take the oath to be a Freemason, you were just excommunicated from the church. What we don't have is the memorial to the event, the actual court case that creates a decree that goes to the Holy See, and now they can shun you, send your ass out to the desert, shut off your account, take over your church property under your all capital letter name. You'll no longer exist. Not you, them. Finally, many causes of their nature civil are accounted mixed by canonists, either because the state relinquished them to the church tribunals or custom gradually caused them to be relegated to the ecclesiastic form, such as the recognition of last wills and testaments and the care of the poor, etc. The encroachment of the civil power on the church's jurisdictions have in our days practically, though unwarrantingly, restricted the ecclesiastic form to spiritual causes only. Okay, well, still matters of faith and sin. It's all that matters. Now, last wills and testaments, right? I'll cover that here in a bit. But ecclesiastic courts, judicial power in the church. In instituting the church as a perfect society distinct from the civil power and entirely independent of it, Christ gave her legislative, judicial, executive power to be exercised over her members without any interference on the part of the civil society. If you have legislative, judicial, and executive power, you are a sovereign state all by yourself. As we know, the Vatican is. And the Holy See is. The Holy See is the government of the Catholic Church, and is headquartered in Vatican City State. What's the territory of Vatican City State? Some people think it's just what's within the walls. I say you're incorrect. I say it's whatever they say it is. They say it's the entire world. Now, if you go back in history, Rome was at one time a city-state. That's what it was. Rome was a city-state. What was its territory? Well, the Roman Empire, as far as they could reach, was their territory. That's what they claimed territory over. The Vatican claims territory over the entire world. From the beginning of the new era, the bishops shared with the secular magistrates the power of settling disputes of the faithful. There you go. Bishops share with the secular magistrates the power of settling the disputes of the faithful. The faithful are all the baptized. So, if you have a complaint against another baptized person, you can take it to the bishop. As it turns out, you don't need to be baptized to take it to the bishop. Right? It doesn't matter if you are, it matters if they are. Constantine the Great published 2 constitutions wherein he not only permits laymen to have their cases tried before their bishops, but also decrees that in all cases which until then were wont to be tried before the praetorian by the civil law should, when once settled before the episcopal courts, be considered as finally adjudicated. Whatever the bishop says goes. In addition to these, there were in the past and are still cases in which the natural and spiritual elements are so co-joined. Bowers from the ancient canonists, the illustration of contract entered by layperson and confirmed by oath. Again, remember, this is excerpts from a video I did last time, right? So not all these necessarily fit together, but they're just points of fact. Here to the obligation of justice is added that of religion, and we easily recognize a twofold juridical element, bringing the matter in question, at least as far as the value and execution of the contract is concerned, within the ecclesiastic as well as civil domain. Right? When you acknowledge your signature on a contract, that's you acknowledging your promise to fulfill the contract. It's a promissory oath. Right? Different than taking an oath for an office, but it's a promissory oath when you sign a contract and take it to a notary and acknowledge it. That makes it a promise. Promissory oath. Where it is a question only of the valid oath, the matter would, of course, be a purely spiritual one. If in medieval times, and so that's what they're trying to do in a court, in a foreclosure, is they're going to say that deed of trust or mortgage only has your signature and a notary seal on it, was your promise to gift and donate the property on that instrument to whomever. And what it was really supposed to be is a bilateral contract signed by the other party, the bank who's supposed to give you the loan, that we both agree that I'm going to give you these securities until I pay back the loan. The bank never signed the contract. And so you can revoke it. And say, I revoked the contract, I've already given you securities, give them back. If in medieval times the church exercised jurisdiction in regard to the temporal concerns of orphans, widows, or other persons of unfortunate condition, no equitable mind will see that therein a usurpation of the civil jurisdiction on the part of the ecclesiastic authorities. Right? So, from medieval times, orphans, widows, other persons of unfortunate condition, the poor, right, the ones who can't find justice, you can take it to the church. The true and adequate explanation lies in the peculiar necessities of the age and the deficient administration of justice and the undue power exercised by the rich and mighty. Isn't that what's happening today? Rather, does it rebound to the honor of the church that she then assumed the defense of the poor against the wealthy and powerful, and came to the aid of those who were deprived of all human help? Get the church involved. tell them it's their duty. If they don't do it, then send a complaint to the sovereign pontiff through the apostolic signature, and we'll start pointing out the heretics that are within the church. The church is full of Freemasons, man. They got to go. They're not going to do their job. It's time to move on, right? The church is supposed to be a church militant. It's supposed to be protecting the faith. It's its duty to protect the faith. That means protect the faithful, the ones who have to be out here in the world, not hid behind the walls of the Vatican City. It must also be mentioned that the medieval and later times ecclesiastical magistrates were often vested in civil power, legitimately acquired, and exercised it not as an ecclesiastic but as a civil magistrate. A perfect example, back in like 1910 here in Michigan, the guy that was the bishop of the Episcopal Church of Western Michigan, it may have just been Michigan at the time, right? So he's a bishop of the Episcopal Church, was also the commissioner of corrections, right? He sat on the board of corrections as the top dog. He had a civil office, right? So he had civil power, legitimately acquired. He had been appointed to the position. I think there's many judges that are bishops in some form, not necessarily the Catholic Church, in another denomination, right? That are both ecclesiastics and civil magistrates. A gal called me, I think it was from could have been North Carolina, Virginia, said in her foreclosure, the judge is a frickin' preacher, right? He knows who she knows who he is. He preaches on Sunday. There he sits as a judge. You better get him in the ecclesiastic side instead of the civil side. Thus, it is not only by divine disposition that the Roman Pontiff is the supreme judge in the universal church, he is also the sovereign legislator, and as the bishops are the lawgivers and judges within their respective dioceses. It must be borne in mind, however, that owing to the special preeminence of the Roman Pontiff, an appeal may always be made from the tribunal of an inferior judge to his tribunal immediately. What's his tribunal? It's the apostolic signatura, the ones who can sign his name, thus passing over the intermediate courts to which, according to general rules, the appeal must otherwise be directed. You always have, the private citizen can always petition the Pope. The question was, how do you correctly petition the Pope? It looks like you're supposed to do it through the apostolic signatura. And that was in an earlier video. It is self-evident that if the civil court was necessary for the proper administration of justice, the place there are limitations on the exercise of the jurisdiction. This is the same restriction as such more necessary in canon law, since the jurisdiction of the church extends to the entire world. What's the territorial limits of Vatican City State? The entire world. In modern civil codes, a private citizen can oblige his fellow citizen to present himself before a judge for examination of a case. Though found in the Roman law of the 12 tablets, the canon law does not recognize in the private individual any such right, and holds that the later procedure of Roman law that dates from Ulpian and Paulus, and are afterwards confirmed by the laws of Justinian, and according to this procedure, the summoning of accused applies the power of jurisdiction and must therefore proceed from the judge himself. In canon law, you can't be called by the bank or a plaintiff to court. Only the judge can call you to court. Summary proceedings are commonly entered upon for one or two reasons, either because the case are such a nature as to demand prompt settlement, alimony, or necessary support. I go to the church asking for money. I need my necessary support. Marriage cases and many cases of ecclesiastics and elections, offices, and benefices. And I think we're supposed to have an office and a benefice, and that's why, do it properly, the bishop can get us our property, get us our membership in the church, our citizenship, our office as a Christi Fieldis within the Holy See, travel documents, and when you do it right, when you get a library card, it'll be for the Vatican Library, not the local library in your town. or because of cases of minor importance, slight and easily remedied injuries comparable to civil lawsuits of trifling debts. And again, in the United States of America, if the case has a value greater than $20, your right to a jury is preserved. You shouldn't be going to all these hearings. You should just be going to trial before a trial of your peers. All right. So, a little bit more, right? Again, we're just going to I'm going to hammer this. Hammer, hammer, hammer. Not so much on you, but to get in the head that, look, don't let the church tell you it's a civil matter and they don't have any jurisdiction. Sure they do. We're going to show them why. But I think what we do is we take our complaint to the office of the chancellor, who would be the chief executive of the bishop is the ordinary, has legislative, judicial, executive power, can delegate. They've delegated their executive power to the chancellor to run the diocese. They've delegated their judicial power to a judicial vicar to handle the cases. Right? The legislative power, I don't think they've given anybody. They kept for themselves. Again, I don't know. But at the end of the day, it's all their power. They're the final determiner. So, the office of the Pope is called the papacy. His ecclesiastic jurisdiction is often called the Holy See, or the Apostolic See, based on the church tradition. The apostles St. Peter and St. Paul were martyred in Rome. The Pope is the head of state of Vatican City, sovereign city-state, and enclave within the city of Rome. That's pretty easy. Ecclesiastic jurisdiction. Primary sense does not signify jurisdiction over ecclesiastics, but jurisdiction exercised by the church leaders over other leaders, not church leaders, other leaders, and over the laity. Other leaders, state leaders, Obama-type leaders. Jurisdiction is a word borrowed from the legal system, which has acquired a wide extension in theology, wherein, for example, it is frequently used in contradiction to order to express the right to administer sacraments as something added to the power to celebrate them. So it is used to express the territory or other limit of ecclesiastic, executive, or legislative authority. So your jurisdiction is basically depends on your territory. Your territorial limits, within that you have jurisdiction. Here it is used as an authority by which judicial officers investigate and decide cases under canon law. Such authority in the minds of lay Romans was first used. This word, jurisdiction, was essentially temporal in its origin and its sphere. The Christian church transferred the notion of spiritual domain as part of the general idea of the kingdom of God, focusing on the spiritual side of man on earth. Now, let's think about this. When the Lord Jesus Christ comes back to earth, is he going to have a democracy or a monarchy? Does a king have a democracy or republic? No, there's only a monarchy. Interesting stuff. There won't be any republics. There won't be any democracies. It'll just be a monarchy. And the church is emulating that monarchy right now. We're not taking advantage of it. It was viewed also ordained of God and who had dominion over his temporal estate. Right? Because this is God's temporal estate. We think it's ours. No, we're supposed to be administering it and conforming the temporal order the way it's administered to the will of the Lord. So the church early on had executive, legislative in its own spiritual sphere and had judicial officers before its union with the state. Right? But eventually they got the union. The church found by Christ for the salvation of men's needs, like every society, a regulating power called the authority of the church. And this decree rejects the doctrine that the church did not desire to found a permanent, unchangeable church endowed with authority. It is customary to speak of a threefold office of church: the office of teaching, prophetic, the priestly office, and the pastoral, governing, right, the office of king, basically, and therefore the threefold authority of the church: and teaching authority, ministerial authority, ruling authority. Canon 204, right? By becoming a member of the church, you share in the priestly, prophetic, and kingly office of Christ. Since the teaching of the church is authoritative, the teaching authority is traditionally included in the ruling authority. Okay. By ministerial authority, which is conferred by an act of consecration, is meant the inward and because its indelible character, permanent capacity to perform acts by which divine grace is transmitted. Fine. By ruling authority, which is conferred by the church, is understood the authority to guide and rule the church of God. Jurisdiction, insofar as it covers the relations of man to God, is called jurisdiction in the eternal form, or jurisdiction in the form of heaven. Jurisdiction, insofar as it regulates the external ecclesiastic relations, is the jurisdiction in the external form. The jurisdiction, the actual power of ruling, legislative, judicial, or coactive. Jurisdiction can be possessed in varying degrees. It can also be held either for both internal and external, or only the internal, such as a parish priest. A parish priest has no power in the external form, only in the internal form. Jurisdiction can be further subdivided into ordinary, quasi-ordinary, and delegated. Ordinary jurisdiction, that which is permanently bound by divine or human law to a permanent ecclesiastic office. Its possessor is called an ordinary judge. By divine law, the Pope has such ordinary jurisdiction for the entire church, and the bishops for his diocese. Within the diocese, by divine law, the bishop has jurisdiction. By human law, this jurisdiction is possessed by cardinals, so a whole bunch of other people can have it too, within their own sphere of jurisdiction. If, however, jurisdiction is permanently connected with an office, but the office itself is said to be quasi-ordinary, this form of jurisdiction is possessed, for example, by a vicar general. Temporarily, exercise of ordinary and quasi-ordinary jurisdiction can be granted in varying degrees. In transient form, jurisdiction is called delegated or extraordinary, and concerning its canon law, the following Roman law has developed exhaustive provision. So there's all sorts of ways to split this power up, right? But the dude who has it by divine law is the Pope and the bishops of the diocese. This development, and so why did they do this? Well, this development began when the popes, especially Alexander III, found themselves obliged by erroneous or enormous masses of legal business, which came to them from all sides as the judicius ordinari omnium, to hand over with proper instruction a large number of cases to third parties for decisions, especially in matters of contentious jurisdiction. And what's the contentious jurisdiction? Well, here you go. Is jurisdiction over matters in controversy between parties, in personam, in contradiction of voluntary jurisdiction, or that exercised over matters not opposed or controverted. The Lord Chief Justice and judges had contentious jurisdiction, but the Lords of Treasury, Commissioners of Customs, have none, merely judges of the accounts. That's why I think when you go into court, the guy you're seeing is like an auditor in the executive branch. He's not a judge from the judicial branch. Contentious jurisdiction in ecclesiastic law. In those cases where there is an action or judicial process, and it consists in a hearing and determining the matter between party and party, me and you, man and man, right? Not man and judge, but man and man, acting as judge. It is said there is contentious jurisdiction, in contradiction to voluntary jurisdiction, which is exercised in the matters that require no judicial proceeding, as in taking probate of wills, granting letters of administration, and the like. So things like where you're doing it voluntarily, like you're acknowledging a deed, whatever it is, right? That's not contentious, that's voluntary, non-adversarial. And this is really just talks about how all these powers can be delegated. Delegate, delegate, delegate. The Catholic Church considers has the right, as a perfect and independent society, provided with all means of attaining its end, to decide according to its laws disputes arising concerning its internal affairs, especially as to ecclesiastic rights of its members, citizens, also to carry out its decisions, if necessary, in suitable means of compulsion, contentious, or civil jurisdiction. This implies a right to admonish and warn its members, ecclesiastic or lay, who have not conformed to its laws, and if needful, to punish them by physical means, that is, coercive jurisdiction. Church's got jurisdiction over everybody who's been baptized, and they can use coercive force to get them to agree. The church has power to judge sin in the internal form, but a sin can be at the same time externally or misdemeanor of a crime, when threatened with external ecclesiastic or civil punishment. The church also judges ecclesiastic crimes in the external form by infliction of penalties, except when wrongdoing has remained a secret. If we don't tell them, the church can't do nothing. In this case, it contents itself as a rule with the penance voluntarily assumed. That's why you gotta go tell them. A last distinction is to be drawn between necessary jurisdiction and voluntary jurisdiction. The later, voluntary, contemplates voluntary subjection to the part of those who seek in legal matters the cooperation of ecclesiastic agencies, notorially executed instruments, testaments, etc. Okay, what's an ecclesiastic agency? I found this off of a very hard to find anything on ecclesiastic agency, actually. But what it says is that non-profit corporations chartered in the state of Tennessee are considered ecclesiastic agencies. Well, hell, almost everything that we think of as government is a non-profit corporation. What do non-profit corporations depend on? Gifts and donations. How is a gift or donation given? By a voluntarily unilateral contract. I'm going to give you my property, right? Like a will and testament. The judicial power above, judicially strictly so called, was given by Christ to his church, was exercised by the apostles, and transmitted to their successors. From the beginning of the Christian religion, the ecclesiastic judge, the bishop, decides matter disputes were purely religious in character. This jurisdiction of the church was recognized by the civil imperial power when it became Christian. But long before this, early Christians, following the exhortation of St. Paul, were wont to submit ecclesiastic jurisdiction matters which by their nature belonged to the civil courts. As long as Christianity was not recognized by the state, it was left to the conscience of the individuals whether he would conform to the decision of the bishop or not. Right? St. Paul didn't want you to go to the civil court if you're a Christian. He wanted you to go to the bishop. But the bishop didn't have any coercive force because, they hadn't been recognized yet. So then they just had to hope that you were going to do the right thing. However, once Christianity had received civil recognition, Constantine the Great raised the former private usage to a public law. According to an imperial constitution, year 1321, the parties in dispute could, by mutual agreement, bring the matter before the bishop, even when it was already pending before a civil judge, and the latter was obliged to put into effect the decision of the bishop. So what's the mutual agreement? Well, if you volunteer because you've put things under notary seals, it doesn't matter. You can take them there. You've agreed that it's under notary seal. You can take it to the bishop. However, a further constitution of 1331 provided that in any stage of a suit, any one of the parties could appeal to the bishop, even against the will of the others. But Arcadius in 1398 and Honorius limited the jurisdictional competence of the bishop to those cases in which both parties applied to him. So it was back and forth, back and forth. But how does a party apply? Well, a couple of ways. And we'll get into it here in a minute. One is by a notary seal. Another is by ecclesiastic agencies, notary seals, testaments, and so forth. Another form of ecclesiastic agency looks like it's the clerk of the court's office. Right? We used to have courts of chancery. Some places still have them. In Michigan, 1848, I think it was, they got rid of the court of chancery, and it was taken over by the civil, or by the circuit court. Took over the powers of the court of chancery. Well, the court of chancery is the court over the chancery. And what's a chancery? It's where the sacred documents are kept. And so when you get the circuit court seal on a document, that's like an ecclesiastic office. Same with probate, which I believe uses the same seal as the circuit court clerk. They have a common seal. Not necessarily the clerk seal, but the court seal. Anyways, in the Middle Ages, the church succeeded in extending its jurisdiction over all matters that offered an ecclesiastic interest. All litigation concerning marriages, matters concerning burial, testaments, compacts ratified with oath, like your promise, matters pertaining to benefices, questions of patronage, litigation concerning church property. Again, what is church property? Your body's the church. It's the temple for the Holy Spirit. It's your property. What's a testament? Under early English law, the term referred to a disposition of personal property by will. But what does will mean? Wish, desire, pleasure, inclination. By your will, you're going to give this property to somebody else. That's voluntary, right? That's a unilateral contract. Now that you've decided to do it, you would write up a contract, have the proper number, and I think it took 3 witnesses, and put it under seal. And maybe you didn't even need to put it under seal at the time. I don't really know. But eventually they got around to putting shit under seal. And boom, right? That's a voluntary unilateral contract. You just gave your property to somebody else as a gift. And that's what they're holding this piece of paper up, this deed of trust or mortgage, saying, hey, he gave it to us as a gift. He promised. See, there's his signature under notary seal. And we have to be smart enough to say, but that's a security agreement, and it's a business transaction, and the other business didn't sign the agreement, so we don't have an agreement. Give me back my securities. In addition, all civil litigation in which an element of sin was in question could be summoned before an ecclesiastic court. All civil litigation in which there's an element of sin, perjury, usury, things of that nature, you can take it to the ecclesiastic court. Also, the ecclesiastic courts had jurisdiction over the affairs of ecclesiastics, monks, nuns, the poor, widows, and orphans, and those persons to whom civil judges refused legal redress. How many times you're going to go into court trying to save your property before you decide, well, this dude ain't going to give me any legal redress, let me go see the bishop. The far-reaching civil jurisdiction of the church eventually overlapped the natural boundaries of the church and state. A reaction against this condition of affairs arose in England as early as the 12th century, spread to France and Germany, gained an influence and justification the more administration of justice by the states improved. At the end of a long struggle, the church lost its jurisdiction in res spiritualis annexial, notwithstanding the claims of the Council of Trent, also the privileges of clergy, and finally jurisdiction in matrimonial cases as far as the civil character was concerned. In regard to ecclesiastic jurisdiction in criminal matters, the church exercised jurisdiction at first only in purely ecclesiastic offenses and inflicted only ecclesiastic punishments. Right? So what's an ecclesiastic offense? Well, if you're taking an oath and don't follow it, you're not following your promise, these are all ecclesiastic offenses, or actually criminal matters. And in the case of clerical disposition, observance of these penalties have been left to the conscience of the individual, yada, yada, yada. Some offenses, especially deviations of the Catholic faith, were by the state made punishable, and civil law and secular penalties were attached to them. Also certain disciplinary misdemeanors of ecclesiastics. That's like where the penal code came from. Conversely, the church in the Middle Ages increased its penal jurisdiction in civil domain by inflictions of varied penalties, some of them purely secular in character. Above all, by the means of some kind of form, it withdrew the so-called clerks from the jurisdiction of the civil courts. Then it obtained from the court held by the bishop during his diocesan visitation not only the punishment of those civil misdemeanors, which involved an element of sin and consequently affected both church and state, but also punished, as such, purely civil offenses. The penal jurisdiction of the medieval church included, therefore, first the merely ecclesiastic offenses of heresy, schism, apostasy, then the merely civil offenses, finally mixed offenses, sins of the flesh, sacrilege, blasphemy, magic, perjury, usury. Those are mixed offenses, right? So the church has jurisdiction over perjury and usury. Canon 1368, a person who asserting or promising something before an ecclesiastic authority commits perjury is to be punished by a just penalty. Question is, who's an ecclesiastic authority? All right, I'm going to assume, so since it isn't really written down, I'm going to assume that they did until somebody says they haven't. But what's this thing about usury? Interesting, right? Church has jurisdiction over usury. Is the practice of making unethical or immoral monetary loans. I would say that's happened. Nobody signed the contract. They didn't loan you any money. All right? That makes your foreclosure, or even if you're not in foreclosure, the payments you're making on your mortgage unethical or immoral. Because nobody signed a contract. The term may be used in a moral sense, condemning the taking advantage of others' misfortunes, or in legal sense where the interest rates may be regulated by law. Historically, some cultures, such as medieval Europe and Islam and many parts of the world, have regarded charging any interest for loans as sinful. Well, if it's sinful to charge for a loan, then guess what? It's usury, and you can take it to the church. Though the Roman Empire eventually allowed loans with carefully restricted interest rates, the Christian Church in medieval Europe banned the charging of interest at any rate. It didn't say they ever changed that. The pivotal change in the English-speaking world seems to have come with the permission to charge interest on lent money, particularly the 1545 Act of our good friend Henry VIII, that heretic. Yeah, man, he's the reason that the Jews could start charging money, usury, on interest on lent money. Now, is interest on lent money different than a money loan? Because the papal prohibition on usury meant that it was a sin to charge interest on a money loan. So if they lent you money, they can't charge you any interest. Let's take that to the church and make them deal with it. The increase of money through usury violated the essence, and according to the analysis, just transactions was once characterized by an equality of exchange, one where each side received exactly his due interest on a loan. An exercise of the principle would violate the balance of exchange between the debtor and creditor, and therefore unjust. Some have suggested the development of the double entry bookkeeping would provide a powerful argument in favor of legitimacy and integrity of usury, but this is an obvious, non-starter. Business has always been accepted as a right and proper activity in all cultures, including those that reject usury. So double entry bookkeeping is a business affair, not a banking affair, I guess what they're saying. It's a sin. It can't be any simpler. The papal prohibition on usury meant that it was a sin to charge interest on a money loan. Go tell the bishop. The bank is guilty of usury. When the sin began to disappear, both ecclesiastic and secular judges were in general held equally competent for mixed offenses. Previous adjudication of the case by one judge or another was decisive. In the matter were brought before an ecclesiastic judge, he inflicted at the same time the civil penalty, not, however, corporal punishment such as the death penalty. If the accusation was brought before the secular judge, the civil penalty was inflicted by him, and the action of the church is limited to the imposition of a penance. The church eventually lost by far the greater part of its criminal jurisdiction for the same reason which, since the Middle Ages, led to the loss of most of its contentious jurisdiction, and in the same manner. Moreover, from the 15th century on, the first arose of France that appeal from the abuse of power by an ecclesiastic authority did much to weaken and discredit ecclesiastic jurisdiction. Some of the jurisdiction in a strict sense. Today, the only object of contentious ecclesiastic jurisdiction, in which, however, the state often takes part or interferes, are questions of faith. So they still have jurisdiction over questions of faith. It's either if it's faith or sin. The administration of the sacraments, particularly contracting and maintenance of marriage, the holding of church services, the creation and modification of benefices, the appointment to and vacation of ecclesiastic offices, and I believe we're supposed to get an office and a benefice that goes with it, the rights of beneficed ecclesiastics as such, right? And now we get particular rights because we're a beneficed ecclesiastic within the church, the ecclesiastic rights and duties of patrons, and the ecclesiastic rights and duties of religious, right? We're not religious, we're just we're going to have an ecclesiastic office, but we're not necessarily religious, we're a lay person holding ecclesiastic office. And the administration of church property. As to the criminal jurisdiction of the church, it now inflicts only on the laity only ecclesiastic penalties and solely for ecclesiastic offenses, such as matters of faith and sin, usury, perjury, things like that. Right? Because when we take them to the church court, it's because somebody is committing a crime against us here in the external form, and that's why we're going to the church court. So everything is really in the criminal jurisdiction of the church. What is an ecclesiastic penalty? Apparently it's the deprivation of some good, spiritual or temporal, inflicted by a lawful authority for the correction of a delinquent and the punishment of wrongdoing. Penalties may be remedial, punitive, penitential. You're asked to go to prison, you're asked may pay some money, whatever it is. As regards ecclesiastics, the power of the church to punish their disciplinary offenses and maladministration of their offices is widely acknowledged by the state. So the question is, if it's an ecclesiastic, first of all, what is an ecclesiastic office? Right? Is a judge an ecclesiastic office? Is a clerk of the court an ecclesiastic office? What is an ecclesiastic office? Because I believe all constitutions to be ecclesiastic ordinances. So then all the offices attached to it would be ecclesiastic offices. And if they've been excommunicated from the church, well, they can't hold an ecclesiastic office, and they could be excommunicated because they're a Freemason if we just brought it to the church's attention. Interesting stuff. So Canon 204, Christ's faithful are those who, since they are incorporated into Christ through baptism, are constituted the people of God. For this reason, they participate in their own way in the priestly, prophetic, and kingly office of Christ. In fact, just today in a letter from Pope Francis was talking about they're going to have some kind of discussion on human trafficking. And in there, he's talking about me, you, everybody else are Christ, as it should be. We are Antichrist. Anti has two definitions, against or another. You can either be against Christ or another Christ, and Christ himself made you a Christ. Right? When you claim the office, you're gonna participate in the office of Christ. Christ is an office. It's an anointed ruler. It's somebody who has been anointed a king, a prophet, and a priest. Canon 205, this is good too. Those baptized are in full communion with the Catholic Church here on earth are joined with Christ in his visible body through the bonds of profession of faith, the sacraments, and ecclesiastical governance. Well, through ecclesiastical governance, for that to happen, for there to be ecclesiastical governance, you had to be part of the society as a citizen. My point is, we should be getting travel documents from the Holy See and give up this, that we have anything to do with the United States of America. Its Constitution was written by Freemasons. So, let me show you something here. This has nothing to do with anything other than this. Here's a copy of an oath of office for an associate judge of the Circuit Court, State of Illinois. David P. Clement. Do solemnly swear that I will support the Constitution of the United States, Constitution of the, yep, faithfully discharge, yep. This looks like a proper oath because it does not have any religious test attached to it. It does not say, so help me God. There's no religious test. And so he signed it, and then the chief judge signed it, but what's this right here? This is This is what's on the record at the county where Roe is. Upon receipt of executed oath of office, the declarant to be placed on the payroll of the judicial branch of Illinois, well, it doesn't look to me like he's ever been put on the payroll as a judge in the judicial branch of the state of Illinois. Yet his ass is sitting on the bench today. Right? He's usurped an office. His oath of office doesn't show that it's ever been completed. And so somebody should get a hold of this Cynthia W. Cobbs, Director of Administrative Office of the Illinois courts, and have a talk with her and find out why the judges haven't been put on the state payroll. And what else do we have? Just real quick, what's the process? So this is back to canon law. So what is the process in a trial? Well, the objects of the trial are to pursue or vindicate the rights of physical or juridical persons, or to declare juridical facts. Well, that means to vindicate the rights of a private person, either as a man or his property, the juridical person, to impose and declare penalties in regard of offenses. The church has its own exclusive right to judge cases which refer to matters which are spiritual or linked to the spiritual, whatever contains an element of sin. Right, now this is right out of canon law, so the church can't say, yeah, we don't have any jurisdiction. Bullshit, I'm reading your fucking laws. Excuse me, Lord. Canon 1405. In the case of mentioned in 1401, the Roman Pontiff alone has the right to judge heads of state. We got to bring him a reason to judge a head of state. So such as whatever the national, can't think of the name of it, but they pretty much sign one every year. And this last one that Obama did, national something. But it's, it's one of these instruments where they're taking away our civil rights, right? So that should be brought up as contrary to Christian beliefs to be able to take somebody without due process and put them in jail, put them in prison, torture them, whatever the hell this thing said, and bring it to the Pontiff's attention. Care of the head of state, Obama. And we'll find out if Obama was baptized or not, because if he was, they got the records in the Holy See in Vatican City. But, certain cases can only go to the Pope. He has the right to judge. What's this? No one can be brought to trial in the first instance except before a judge who is competent on the basis of one of the titles determined in 1408 to 1414. So, first of all, the competent judge of a diocese is the bishop, and so no one can be brought before the bishop unless one of the following apply. The plaintiff follows the form of the respondent. So, if the respondent was from a different diocese, you're supposed to take the action to his diocese. Anyone can be brought before a trial of a domicile or quasi-domicile. Right? Where's your domicile? Well, in here it says if you've lived within a diocese for 5 years, it's your domicile. And you really want to claim the domicile of the church because your domicile determines where you can sue and be sued from. And if you're domiciled in the diocese instead of in the county, well then under canon law, if somebody wants to bring a claim against you, they need to bring some witnesses and swear to it. And that doesn't happen in the county. A person whose domicile, quasi-domicile, place of actual residence is unknown can be brought to trial in the form of the plaintiff. Competence by reason of subject matter means that a party can be brought to trial before a tribunal, the place where the subject matter of litigation is located. Right? So if we're talking about real property, you can bring it, and you're within the jurisdiction then, and the bank is who knows where, doesn't matter, because the property is here within the jurisdiction of the bishop of your diocese, you can bring it to him. Competence by reason of contract. Where was the contract signed? obligations arose or to be fulfilled. In case of concerns, obligations of the title, some other title, a party can be brought to trial before the tribunal of the place in which the obligation arose or in which it is to be fulfilled. Right? So we don't necessarily need to go to where the respondent is. Depends on where the contract is. A party can be brought to trial in cases concerning administration before the tribunal in the place in which the administration was exercised. In cases concerning inheritance or pious legacies, before the tribunal, the last domicile or quasi-domicile or residence of the person whose inheritance or pious legacy is at issue. So, what's an inheritance? Well, an inheritance is everything that is supposed to be given to you that wasn't given to you by will. First of all, your ancestor by will can give to whomever he wants, whatever he wants of his property. Whatever's left is supposed to be split up equally between the who's left. So, if we're the adopted sons of the Lord Jesus Christ, all children of God, we have an inheritance from the Creator. Could be a pious legacy, right? And where is that at? Well, that can be worked out in the domicile or residence of the person who's at issue, which would be you. Got to work that one out, but I think that's one way to get our property back. Different grades and kinds of tribunals. Because of the primacy of the Roman Pontiff, any of the faithful may either refer their case to or introduce it before the Holy See. Right? So you can either appeal or take it to them directly. Every tribunal has a right to call on other tribunals for assistance in instructing a case or communicating acts. Why? Because they're all part of one ecclesiastic governance. In each diocese, and for all cases which is not expressly accepted by law, the judge of the first instance is the diocesan bishop. In a case concerns the rights of temporal goods, the rights or temporal goods of a juridical person represented by the bishop, the appeal tribunal is a judge in first instance. Right? So rights or temporal goods of a juridical person. Now, what is a juridical person? Right? Is that your legal name, your all caps name? Is that the juridical person and they're represented by the bishop because you're domiciled within his diocese, and if you are, that makes him your agent. That goes back to what it said about claiming the domicile in a township, that when you did that you could appoint the board as your agents and attorney. And basically that's what you're doing, is you're claiming a domicile, makes the bishop your representative. The judicial vicar constitutes one tribunal with the bishop. Each diocese, the bishop is to appoint a diocesan judges. With the approval of the Apostolic See, several diocesan bishops can agree to establish one tribunal of first instance in their diocese. So one court can cover many dioceses, and they do this, I think, in poorer countries. Some things take a collegium of three judges. Penal cases, importance of judgment of 3 or 5, right? It can have up to 3 or 5 judges. The task of auditor is solely to gather the evidence in accordance with the judge's commission, and when gathered, to submit to the judge. And I think that's what happens in court when you go for a foreclosure. The dude there is the auditor, and he's just gathering evidence for the court case to take to the judge. We're never actually seeing the judge. You're not. I don't have any property. Promoter of justice. A promoter of justice is to be appointed in a diocese for penal cases and for contentious cases in which a public good may be at stake. The promoter is bound by office to safeguard the public good. So if you bring a complaint for a contentious or penal case to the bishop, they're going to assign basically a prosecutor, promoter of justice, who's going to represent you. In contentious cases, it is for the diocesan bishop to decide whether the public good is at stake or not. It is the bishop's responsibility to appoint the promoter of justice and defender of the bond. Acts drawn up by notaries constitute public proof. Okay, so that's the first instance. What's the second instance? This is where you would appeal. An appeal from a tribunal of a suffragan bishop to the Metropolitan Tribunal without prejudice of the provisions. Okay, so a suffragan bishop is like the bishop of a diocese, or even in the metropolitan. So the Diocese of Detroit is where the metropolitan is in Michigan, but the archbishop doesn't directly administer the law over the Diocese of Detroit as a Diocese of Detroit. He has another bishop that does that. The archbishop sits as the chief magistrate of the province. And when it says province of Detroit, when you look at a map, it's all of Michigan. The Roman Pontiff is the supreme judge of the whole Catholic world. This tribunal, which is the Roman Rota, judges in the first instance the cases mentioned in certain canons and any other which the Roman Pontiff, either of his own initiative, requests the parties as reserved to his tribunal and as entrusted to the Roman Rota. So the way it sounds is we're supposed to take our complaint, we give it to the chief executive, which is the chancellor's office. They're supposed to review it and decide what court it goes to. Now, this hasn't worked out yet. This is just theory of people talking that have gone out and tried some things and trying to put together little bits of information we have to go to the next level and try it again. And the Supreme Tribunal, the Apostolic Signatura, hears. This is where it talks about recourses for status of persons, conflicts of competence, yada, yada, yada. I've already covered that stuff. All Christ's faithful, especially bishops, are to strive earnestly with due regard for justice to ensure the disputes among the people of God are as far as possible avoided and settled promptly without any rancor. It's the bishop's job to do that. That's why we're going to take it to him. He is to indicate to them suitable means to this end and avail himself of serious-minded persons to mediate. So what he can do is get an arbitrator involved. So it doesn't need to go to court. If the issue is about the private good of the parties, the judge is to discern whether an agreement or an adjustment by an arbitrator in accordance with the norms of some other canons might usefully serve to resolve the controversy. Let's let them make a decision. In a matter which concerns private persons exclusively, a judge can produce or proceed only at the request of the party. Right? So if we don't bring it to their attention, there's nothing they can do. In penal cases, however, and in other cases which affect the public good of the church and the salvation of souls, once the case has been lawfully introduced, the judge can and must proceed ex officio. Once we bring it to their attention in a penal matter, they have to take it to the end. That's the way it sounds to me. They need to render a judgment on if the individual is guilty or not guilty of a penal offense. Judges and tribunals are to ensure that within the bounds of justice, all cases are brought to a conclusion as quickly as possible. They are to see to it that the tribunal of first instance cases are not protracted beyond a year, and tribunal of second instance not beyond 6 months. All who constitute a tribunal or assistants, it must be taken oath to exercise their office properly and faithfully. Now remember, this is if we're going to a full-blown court. He can just as easily make a summary judgment from the steps of the cathedral. And make a phone call and boom, that's over, right? He can get arbitrators involved, but if it's a penal case where it has to go to court, well, they have to have it done within a year. In a penal trial, the judges and tribunal assistants are bound to observe always the secret of the office. In a contentious trial between two people, they are bound to observe it if the revelation of any part of the acts of the process could prejudice the parties. Indeed, the judge can oblige witnesses, experts, and parties and their advocates or procurators to swear an oath and observe secrecy. The judge can be punished by contempt authority with appropriate penalties, not excluding loss of office. So, this stuff is pretty pretty powerful stuff that we have available to us if we just take it to the right court. We can impeach the judge. Not that we want to. I'm not saying they're going to do the wrong thing, but there you go. They can be charged with contempt. And that's what we do if they don't take your court case. And you're correct. We're going to petition the Pope and say, hey, the judge is in contempt. He's not handling this matter. Cases are to be heard in the order in which they are received and entered in the register. Right? So somehow we need to get our case entered into a register. Defects which can render a judgment invalid can be opposed or proposed as exceptions. Okay, so, it doesn't sound like it's that hard to put anything in. Questions concerning the guarantee of judicial expenses and the grant of free legal aid, which has been requested from the very beginning of the process, and other similar matters are normally to be settled before joinder of the issue. All right. Any person baptized or unbaptized can plead before a court. A person lawfully brought to trial must respond. Even though the plaintiff or respondent has appointed a procurator advocate, each is always bound to be present in person at the trial when the law or judge so prescribes. Those barred from administration of their goods and those of infirm mind. So here we go. Those barred from administration of their goods. Are we barred from administration of our goods? How do we find out? Let's have a status hearing. Judicial persons stand before the court through their lawful representatives. If you bring the bank to court, their attorney isn't going to represent them. The bank's officers are. They're the lawful representatives of the bank. In a case of absence or negligence of a representative, the ordinary himself, either personally or through another, can stand before the court in the name of the judicial person, subject to his authority. If they don't show up, he'll become the bank. A party can freely appoint an advocate and a procurator for him or herself. You can freely appoint an advocate and procurator for him or herself. Right? Freely appoint. When you appoint somebody, do you have to pay them? I don't know. They work for an honorarium. Maybe you give them a meal. So, you've got to find out who is an advocate that you can use, and you could appoint one. In a contentious trial, which concerns minors of public good, the judge is ex officio to appoint legal representatives for parties who lack one. Right? So if it concerns minors or the public good, the judge is to appoint legal representation. Every right is reinforced not only by an action, unless otherwise expressly provided, but also by an exception. I don't really know why I highlighted that one. A person who advances arguments which are at least probable to support a right to something held by another and to indicate an imminent danger of loss of an object, unless it is handed over for safekeeping, has the right to obtain for the judge the of a object in question. What is that? When they secure the object. Right? So we can have them secure the account that's being held by somebody else, because they may run off with it if it's at least probable to support the right of something held by another. Can extend to the assets of a debtor, which on whatever title are in keeping of others, as well as loans of the debtor. Right? We can get them to grab our accounts if we're the debtor, supposedly. Grab our assets and let's grab the assets. Let's have an audit. Figure out what I owe, take it from the assets, pay it off, give me the rest. We can all go home and have a great day. And matters concerning the nature and effect of an action of possession, the provisions of civil law on the place where the thing to be possessed is situated are to be observed. A judge cannot investigate any case unless a plea drawn up in accordance with canon law is submitted either by a person whose interests are involved or by the promoter of justice. A person who wishes to sue another must present a petition to the judge who is lawfully competent. In this petition, the matter in dispute is to be set out and the intervention of the judge requested. A judge can admit an oral plea whenever the plaintiff is impeded from presenting the petition, or when a case can be easily investigated and is of minor significance. In both cases, however, the judge is to direct a notary to record the matter in writing. This written record is to be read to and approved by the plaintiff, and it takes the place of a petition written by the plaintiff as far as it affects the laws are concerned. I remember reading back in Michigan civil law, the Michigan compiled laws, and this had to do with small claims court, where it said you were supposed to go in and the clerk would write your complaint for you. And that's what it sounds like they're doing here. The petition by which a suit is introduced must state the judge before whom the case is being introduced, what is being sought, and from whom it is being sought. Indicate on what right the plaintiff bases the case, at least in general terms, the facts and evidence to submit to support the allegations made, signed by the plaintiff or the plaintiff's procurator, bear the day, month, and year, as well as address of which the plaintiff or the procurator resides, or which they say they reside for the purpose of receiving the acts, indicate the domicile or quasi-domicile of the respondent. Right? Those are the four things you need to do to put in a petition to the judge. Canon 1504. Once he has satisfied himself the matter is within the competence and the plaintiff has a right to stand before the court, the sole judge or the presiding judge of the collegiate tribunal must, as soon as possible, by his decree, either admit or reject the petition. So now this sounds like we don't necessarily give it to the bishop, because the bishop may have appointed a judicial vicar. We take it to him. The petition can only be rejected if the judge or the tribunal is not legally competent. It is established beyond doubt that the plaintiff lacks the right to stand before the court. The provisions of 1504 1-3 have not been observed, right? So if you haven't done this, 1, 2, and 3, doesn't say you have to do number 4. You got to do at least the first 3. Well, then, right? It could be rejected. It is certainly clear from the petition that the plea lacks any foundation and that there is no possibility that the foundation will emerge from the process. Now here's an interesting thing, because in Bob's case, we didn't know what they were going to do, so we made our complaint about a traffic ticket and it not having the proper words on it the state law says it's supposed to have, and send it to the Apostolic Signatura. So it sounds like they could have said, well, we're not going to send it through, because they had the tribunal look at it, and yet they sent it through to the Apostolic Signatura. It's beautiful. It is certainly clear, if the petition has been rejected by reason of defects, which can be corrected, the plaintiff can draw up a new petition correctly and present it again to the same judge. A party is always entitled within 10 canonical days to have recourse based upon stated reasons against the rejection of a petition. This recourse is to be made either to the Tribunal of Appeal or if the petition was rejected by the presiding judge, to the collegiate tribunal. A question of rejection is to be determined maximum expedition. If within a month of the presentation of the petition the judge has not issued a decree admitting or rejecting it in accordance with Canon 1505, the interested party can insist that the judge perform his duty. If, notwithstanding this, the judge did not respond within 10 days the party's request, the petition is to be taken as having been admitted. So you're supposed to give them 30 days and ask them, well, where's the decree? If they don't respond within 10 days, then you're supposed to take that it has been admitted. So it hasn't been rejected. It means they're working on it. They're just going to be quiet about it. In a decree by which the plaintiff's petition is admitted, the judge or the presiding judge must call or summon the other parties to court to effect the joinder of the issue. He must prescribe whether, in order to agree the point at issue, they are to reply in writing or to appear before him. If from their written replies he perceives a need to convene the parties, it can be determined this by a new decree. So he isn't going to issue orders, he's going to issue decrees. In a petition, it is deemed admitted in accordance with provisions of 1506. The decree of summons to the trial must be issued within 20 days of the request of which the canon speaks. If the litigants in fact present themselves before the judge to pursue the case, there is no need for a summons. The notary, however, is to record the acts of the parties and present at the trial. Yada, yada, yada. Anywho, it looks like we could take stuff to the Catholic Church, to their court. They have jurisdiction over quite a few things. And you know, again, this is for anybody. Where is that thing? Go back to where we began, and then I'm going to call it a day as soon as I remember where it was. Offenses against human life and liberty. One who commits murder, or who by force or by fraud abducts, imprisons, mutilates, or gravely wounds a person, is to be punished according to the gravity of the offense with the deprivations and prohibitions mentioned in Canon 1336. If you know anybody who's gone to jail and there hasn't been a sworn complaint put in, Canon 1397, and your local judicial vicar are going to go together, one way or the other. I'd be making some phone calls. Let me know what they say. Okay, good enough for today. We'll see ya. Take care.